Deputy Laura, I'm gonna put you in charge of the mouse.
No, it's okay.
All right, thank you.
Well, I'm in your head though.
Okay.
So you already responded to that email,
All right, thank you.
but,
All right, and everyone, as I stated before, a jury should probably be up here by 10 or 10:30. They're just qualifying the jurors in the jury room.
and Judge, I text Mike that his paperwork is ready.
I'm sorry, who's paper?
Miguel Hernandez, I texted him paperwork.
All right, thank you. So we'll take up this plea and then we will see where we are for trial.
While it loads, you can just go ahead and give me the card number. and I can-
Okay, it's 2022 CR 5205. I just want to make sure that the complainant knows that the case is being terminated, if they need to know. Okay, all right, thank you. And I am loving my flowers. They are, I'm like, and they smell great. Deputy
Oh, yeah,
Laura,
the victim will be-
I'm sorry.
the victim will be-
All right, thank you. All right, I have signed it. Deputy Laura, you know, some days you come to work and there are beautiful surprises. All right, Norma, and can you see where Miguel is?
Yes. Yes. Okay. I have to also go on for like 11 until after. So early morning, late afternoon.
Let's see, I got 2024.
But because it's something outstanding, I wasn't able to see what was on the
Can you
phone.
sort them out? Someone happy previously, but it-
Did he, in jail?
no, he's not in jail.
Is he here?
Just yada yada. Yeah, he's right there.
Okay. You brought the file and I just had to choose what them. I don't know. Did you confirm it, right?
It's already to me. He told me it's set, so it's I wanted to confirm. So I was right. It is.
Yeah.
Okay. Well.
But how it is that it was in the computer system, I wasn't able to look. So.
Yeah.
Bless you.
I think I had everything. There's no applications. Okay.
Yeah, it was crazy.
Yes. I'm sorry, what?
What stadium check?
No, we can even get.
Oh, sure. I'll see if we can get stadium seating. That would be awesome. Now, let's see what the chances of that are happening. Hi. Okay, so is he done with probation? Okay, all right, sure. Yes, sure. Yes. Hello,
Oh,
hi.
it's nice to see you. Brought you some flowers.
Oh, thank you so much.
Yes, ma'am. I don't know if you remember me, Fabian Rosas.
Yes, I do. You were on probation with us.
Yes, ma'am. Yeah, we're just here showing some support for my partner, Adorned. She's here, so she's got a couple of settings.
Okay,
I figured we'd bring you some flowers and
all right.
Just
Well,
say hi.
and you're no longer on probation?
no, ma'am.
All right, well, congratulations. Hi, guys. Hi. All right, well, keep up the good work, okay?
We appreciate it. Thank you.
All right, thank you. Well, Sean, it's so nice when people do well on probation and they've completed everything.
Absolutely.
I'm like, oh,
It makes my heart.
yes. And you know, you have a lot to do with that. Thank you. All right, who's here? It's going to be a great day. Who's here on Victor Garcia? All right, if you all will approach, please. We're going to go on the record. Let me see if I can find the print. All right, court is calling 2022 CR 11858, State of Texas versus Victor Garcia. Can I have parties announced for the record for the state,
Kelly Jackson for the state.
for the defense?
Miguel Hernandez for the defense.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions
Yes,
with
ma'am.
your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by indictment, you're charged with the offense of murder? The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no, Your Honor.
Anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 35 years in the prison, and there are no applications. Of course, you're not eligible for deferred adjudication for murder. Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 with all attachments.
We've had a chance to review, Your Honor, no objections.
Mr. Garcia, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We do.
All right, anything you wish to say on behalf of your client?
Your Honor, we would ask that the court go along with the plea bargain offer. We believe that it should satisfy the actions of my client. He's taking full responsibility, Your Honor. The only thing we would ask, other than for you to follow, is that there was a mental situation. He has been psyched, he has been competent, found competent, but he is on medication. So we would ask that for his sentencing, if he be put in the medical units, the court could recommend that for him, because I believe that he does have mental issues, but the medication is taking care of it. And it was determined at the time of the incident, he did know he did streamline.
All right. State,
Your Honor, the family is present in the courtroom. If you don't wish to get it.
all right, and so they're aware of this sentence and in agreement with it? All right, the court is finding you guilty. The court will sentence you to 35 years in the prison. There's credit for any time served. And I'll request the mental health unit. However, it's completely up to the prison, but I'll request the mental health and
Thank you, Judge.
therapeutic unit. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I understand that sometimes people do things and then later they regret it. I read the stipulations and I see in the stipulations that there's issues of maybe drug-induced psychosis and also mental health issues on top of that. You're going to have to change your ways. You're going to have to get a handle on your mental health issues and also your drug issues. Do you understand?
Yes, ma'am.
Because somebody is no longer here because of your actions. All right, good luck to you.
Thank you, Your Honor.
You're welcome. Thank you, Miguel.
Excused, Your Honor.
Yes, thank you. Could I see the file on Sergio Morris?
Right, it would just be people.
Yeah. All right, thank you. State on Sergio Morris, he's on the first page. This is one of those cases that I guess Odyssey just put in the system. But I want to make sure that that case is taken care of and it's not just floating out there and he was always a fugitive. So what I'm going to do is we're going to reset it. And Norma, if you can have someone from Alan Brown's office come over because they're listed on this case. And then what I'll do, State, because I know you all are in jury trial. Norma, let's set this for July, the end of July. All right, we'll set it for July 30th. So if you all can give me an update. All right, and then who's here on Floyd Allen?
I am just,
Yes.
I was just requesting an investigator to help me. If you recall, this is the gentleman who's too heavy to come up to court.
Mhm.
And I need to he told me of some things that need to be tracked down, his property at the jail, some other reports, and I'd ask the
Sure.
investigator to help me get that together to get ready. I do not anticipate a lot of money. If you ordered 1,500, I don't think it would probably come in perhaps even half of that.
Okay.
to avoid having to come back in the time. Get ready.
All right.
Thank you very much.
You're welcome.
Mr. Attorney, what's your name?
Warren Wolf,
Warren Wolf.
yes.
I'm sorry.
All right, Norma, where's the attorney for Jimmy Dotson?
I told him to be here by 10:30, Judge, I'll call him.
All right, thank you.
But he's gonna walk out.
All right. All right, could I see the file on Juan Ramos? Oh, he has his own theme music. I like that. Ah. My mom always says everyone should have their own theme music. All right, so we're going to start with Mr. Dotson. He's in custody. So state defense, which case are you all proceeding on? Or both parties have agreed to proceed on? I know there was one case that Mr. Stenberg said that he didn't want to proceed on that case first.
Proceed on 3153, Your Honor.
Is that correct, defense?
Yes.
All right.
The
So
doors
we'll-
are outside, so.
All right, if we could place the other persons on hold, because we're going to see if this actually is going to go forward. And then the other people in the courtroom, you need to come back by 1:30. If you're on the docket for today, come back at 1:30.
Mr. Dotson?
Yes, sir. Yes, if you're on the docket, these are the people who need to come back to this court at 1:30. Camila Scalvon, Arturo Villanueva. Yes, come back at 1:30, okay?
Thank you.
All right, thank you. And could I see that file on Jimmy Dotson, please? Thank you.
I just want to make sure.
Jesse, I.
Yeah, it's on the docket. You have to come back at 1:30.
Okay, I just didn't hear my name.
Yeah.
All right, thank you. We'll see you back at 1:30.
Brock, come back at 1:30.
Thank you.
Judge, those were the only two cases that were left for today.
Okay.
But I just pulled them off. So.
That's okay. All right, we'll have them come back at 1:30.
Judge,
Yes.
on, Rudy Luna. You checked the box for indication error law, but it didn't how many months is that until further notice or?
Yes, let's do until further notice, because I see there are issues with him. I'm sorry. Sure, just one moment. So, Sean,
You don't have any mics up here other than yours?
Mhm.
Yes.
All right, the court is calling 2024 CR 3153, State of Texas versus Jimmy Dotson. Can I have parties announced for the record for the state,
Andrew Harris Edelman.
for the defense? All right, and are you Mr. Dotson? Counsel, have you received all the discovery that you reviewed with your client? All right, the court will find that the state is in compliance with discovery. And the other thing, counsel, is the acknowledgement, I'm sorry, the election of punishment. Thank you. Yes. And for the election of punishment, what has he chosen? All right, he's coming to the court for punishment. All right, thank you. All right, are both parties ready to proceed, state,
Yes, Your Honor.
defense? Yes. All right, Deputy Laura, just give us a moment.
Yes, Your Honor.
Yes.
Escobar wanted to announce his presence for the state.
Daniel Escobar for the state of Texas.
All right, thank you. And state, if you want to upload your documents, you can do that now.
I got it. Without one. Yeah. So it's vibrating. What do I do?
When in doubt, turn it off.
What do you doing?
Let's see.
When I have it on vibrate, why is it ringing?
It's not on vibrate.
It was. It says vibrate. Let me just turn it off. That'll work.
Oh, you have it password protected here.
So is this your first
Yeah, hold on.
viewing of a jury
Just go ahead. and just
selection?
Lower it down.
Okay,
No,
all right, well, welcome.
the media is
So
all.
and I will tell you, every court does their jury selection differently.
Now it should be vibrating.
I based how I do my jury selection
It should
on
vibrate now.
what I would have liked to have been done when I was a defense attorney and also when I was a prosecutor. So sometimes you will have people who do specific separately from general. And general is just, you're asking your general questions. Specific is you're asking questions of jurors individually. So in this court, I just give
There
state
you
a block of
go.
time and defense a block of time. And some judges want you to strike somebody for cause in front of the entire panel. And I don't like doing that because, one, maybe people will be upset that you're saying that I can't be fair in front of everybody and maybe hold it against you. You always hope that they never would. And I've done jury selection in judges where they make you do a strike in front of the entire panel. And then what ends up happening is you're arguing or presenting your points in front of that specific juror. And then you have maybe the state or the defense attorney trying to save that specific juror. And so even though you're hopeful that jurors will not hold it against you, they may feel some sort of way that you were trying to get rid of me and this person was trying to save me. So I don't do that in this court. Mhm.
Judge, we made a time announcement for how much time for each side?
I'll give each side, since y'all are not going to the jury for punishment, I think 30 minutes each side is good.
That should be plenty, Judge.
All right.
Jason, there's an extra chair for you.
What?
There's an extra chair for you.
Oh,
Put it on the corner in the back.
Is it right there?
No. Which one is it? Where does Jason want to sit?
Oh, upstairs, watching YouTube. I mean, I was trying to give you some credit. Yeah, I mean, I was about to, but you're good. It's fine.
All right, counsel, Mr. We're gonna proceed. Mr. Steinberg. All right, you all have till 10:15.
It's 11, Judge.
I'm sorry, 11:15.
Let the jurors know just to,
Yes, we're calling the jurors in at 11:15.
Number of rules.
Yeah, you did.
Oh, I think we'll be done, probably,
Tomorrow afternoon.
yes, they'll be done tomorrow afternoon.
Maybe sooner, depending on how quick we get these things. Then,
Daniel, sooner, I like to meet. I heard that.
hey,
Mhm.
always try and be as diligent and quick as possible.
We know, so we have two landscapers, one next week.
Yeah. Thank you. This is, the same.
Thank you. That's like
50.
40.
One time in a closing argument. You know, he was doing because I was thinking because.
Yeah.
Yeah, like. inside.
Remember that?
Yeah, we would like do delete like. Do it.
One's usually it's now.
You got slide happy.
I don't think it's supposed to be requires a lot of concentration.
Some of it helps, it can help, but
It can. I don't think it's necessary. Yes.
no. Let's just say this, for grading close, I'm just gonna waive my time. These are free. So how much I'm gonna ask.
I'm even gonna take on this.
Yeah.
Now, here you go. But no, here's a second one, it'll be long.
Okay, now that was a happy topic. That's a happy rose right there.
It'll be long.
Yes, it will be lonely.
How many witnesses are you all anticipating?
Probably 4, but it could be cut down to 3 easy.
Oh, no, but you can get any of this. It's like jury selection. Okay. I will tell you if you're going to defense attorney. Sometimes when you're doing the jury selection.
You actually are sitting by yourself to do jury selection. But usually with the defense bar, if you want someone to sit with you and you give them an advance notice, usually you can find an attorney who will sit with you with, that will take notes. But normally, you're by yourself. Yes.
Jury, it's never bothered.
Okay, this file. I think I have
These two files. And I think it's some. Probation.
Oh, yes. So this is the one where the GPS. Guys on GPS, but it's revising the GPS on the trial.
Yeah. Which one is that? If you can.
The complainant know, and Ally sent an email. And so I forwarded that email that Ally sent to you. To see if we need to go ahead and get them off of the GPS. You were supposed to have it. You, but that would be get off the first.
Something they have. The battery died. Sure.
Will you put in?
Or that means that. Yeah, we're starting jury trial. We're going to come back to you.
know what? How do we come in?
Then we just put on the record that the state is going to, so that they can check. So just any dates you want to put on it, I'll take care of it. All right, let's bring the jurors in.
Yes.
Any judge? Yeah, we're bringing the jury in.
I'm only on number 20.
I'm sorry.
Well, it's not my fault, this stuff and.
No, I mean this, when did this come up here, Ms. Ferguson? When did they drop it off? They dropped it off at 10:30, so that's been sitting up here since 10:30.
Well, here's my fault. They started a plea, not a plea, a sentence in 227. And water till 10.
Mhm.
Two attorneys, 4 different cases. Same time. We didn't finish until I was here.
I mean, this was scheduled to start at 9. I don't understand why people don't take better thing of their time. I've been a defense attorney, I understand people have to be everywhere, but everybody's just running around, not following instructions, like he was sent at 9 today. And I told everybody to be here at 9. I said the jury would not be here till 10. I said, but be here at 9, and they're gonna call the jury up, because they will qualify them by 10. And then everybody will scatter and run wherever, and now the jury is out in the hallway, and they've been out there for how long?
Since,
For about an hour already.
Like, they've been out there since an hour.
I don't want to repeat what I already said.
Yeah, I know, but I'm frustrated by the fact that people don't come up and are not ready.
20.
All right, continue to review with him what you have.
Maybe be seated, John.
Yes. It's right there. There. All right, and so, I'm sorry, Mr. Steinberg.
Yes.
Are you reviewing to request a shuffle? Okay, then the jury can come in. If you're not reviewing to request a shuffle, that's what you all look over and question the juries. The state is gonna go first with their questioning and you'll go second with yours.
With all due respect, I've got to be able to listen to them.
Well, I tell you what, you can listen to them and I will give the jury a break between their voir dire and your voir dire. Okay?
How's that for you?
Yeah, it's voir dire, it's a state.
I
I appreciate you, Mr. Sexton. All right, let's bring the jury in.
All right.
Each side has 30 minutes. Ready, Judge? Yes.
Right.
Dodson. Every time the jury's in, that means it's gonna. Come on. Over here, ma'am, first row. First row, it has the numbers on the chair, okay?
Okay.
Number 8, second row on top, has the numbers on the chair. Please put your phone on silent. Number 15. Number 15, it's on the bench. It's on. Just press it. Number 30. Okay, 30, you're in the row. Man. And you man. Number 37, next row. Forty-four. 51. Next one. 57. Right here next to them. 51. All right, everyone, please be seated.
All right, everyone, good morning, sort of good afternoon. And what should the response be? Good morning, sort of good afternoon. All right, and what should the response be? Good morning.
Good morning. Good afternoon.
Good afternoon. Thank you. All right, everyone, this is the 187 District Court. I'm Judge Stephanie Boyd. You are on the 4th floor in the 187 District Court with Judge Boyd. So where are we? What floor? What's the court number? And who's the judge? Now, I know what you're saying. Judge, we've been standing outside. We know where we are. Here's the reason why I always do that, because we will take breaks. And when we take breaks, jurors are not allowed to stay in the courtroom and jurors end up getting lost. We've had situations where jurors, we're waiting for them and we're waiting for them. And then we find them in another trial trying to get on that jury because they think they're in the correct place. So whenever we take our breaks, if you're ever lost and you look up and everybody's gone, because that tends to happen, all you need to remember is either the 187th court, you know you're on the 4th floor, or either remember Judge Boyd. I'm the only Judge Boyd in the entire courthouse, so you will never be lost. So you're here for a trial today. It's the state of Texas versus Jimmy Dotson. State, if you can introduce yourself, please.
Daniel Escobar from the state of Texas.
Andrew Harris Edelman.
And for the defense.
Howdy, y'all. Let me say howdy, y'all, too. My name is Joe Stenberg. I'm an attorney in San Antonio, and I'm proud to introduce my client, Jimmy Dotson. Y'all see, I'm standing in the way.
All right, thank you, Mr. Stenberg. All right, so I'm going to be talking to you for a little bit, and then the state is going to have a chance to speak with you. And once the state speaks with you, I'm going to give you all a lunch break, and then we'll come back and the defense attorney will speak to you. So the persons who have just stood up, is there anyone here who recognizes any of those parties or knows any of those parties? If you do, please raise your card. All right. Now, in your possession, you have something that's very valuable. It is a card. And that card has your juror number on it. I always said that if ever I were in a position to make somebody's job easy or easier, I would. So today, we're going to make the court reporter job hopefully easier. So to my left is the court reporter. She takes down everything that everyone says. So if you can imagine, everybody speaks at a different tone. Some people speak extra fast. Some people whisper. The tone and the volume that I'm using, that's the tone and volume that she needs in order to be able to hear you all. Because with the court reporter, her record is very important. If it's not in her record, it didn't happen. And in this court, everything that happens in trial, I want people to know that it happened by her record. So we need to all agree to speak one person at a time. And I know sometimes attorneys and people get involved in conversations and you tend to finish each other's sentences or talk before a question that's been completed. Please do not do that because she can only take down one person at a time. Does everyone understand? Now, I want everyone to raise your cards for me. All right. Now, When I ask you to lower your cards, I want you to, people 21 and 20 are getting anxious. When I ask you to lower your cards, I want you to lower those cards for me, okay? Everyone in this box, please lower your cards. Everyone on the front row from 15 to 21, please lower your cards. Everyone else, if you still have your card up, what that means is whenever you want to answer a question, if you can, I'm going to need you to stand because the acoustics in this court is not good and the court reporter will not be able to hear you if you do not understand, if you do not stand. Does everyone understand?
Yes.
All right, I'm hoping you all will be the first jury that we've ever had who will follow that rule. All right, you can lower them. All right, the charges in this case, there are 3 counts. The first count is possession with intent to deliver 4 to 200 grams. The second count is possession 4 to 200 grams. And the third count is possession less than 1 gram. Now, when I speak to you, when the state speaks to you, when the defense speaks to you and asks questions, they're all talking in hypotheticals. Neither the state or the defense can tell you what they think the facts of this case are. So whenever they're asking you questions, don't go into your mind and think, oh, this must be about Mr. Dotson, and this must be about this specific case. The only way you will learn what parties thinks the facts are in this case is if you're selected for the jury. Does everyone understand?
Yes.
Now, I want to talk to you about an indictment. In felony courts, the only way a case is really brought to trial normally is if someone has been indicted. An indictment just tells a party who's accused what they're being accused of and where they need to be to answer for those accusations. Does everyone understand? It is not it's not evidence of guilt. It cannot be taken to mean anything. Does everyone understand? All right, so how many people here we're going to test you raising your cards. How many people here have had a traffic ticket before? Okay, so that continues with their bad drivers in San Antonio. There are a lot of bad drivers. All right. So I've had a traffic ticket before too. And I'm going to give you a hypothetical. Let's say you are accused of running a stop sign. So the officer pulls you over. And when I had my traffic ticket, they still had the little paper books and they give you the paper. Now I think they do something different. And they give you a ticket and you accept that ticket and it will tell you, you ran a stop sign. This is where you need to appear. And usually it's municipal court on Frio or somewhere else. My traffic ticket was in Louisiana because that's where I'm from. So when you get that ticket and that officer gives you the ticket, you're accepting of that ticket. You're not saying, oh yeah, that's right, I ran a stop sign. That's not what you're saying. You're accepting it so you'll know what you're being accused of. And when you go to municipal court, they're going to say, you're here because an officer accused you of running a stop sign. That ticket is not going to say, oh, you know what? I know you think you're here for running a stop sign, but we're going to do a switcheroo on you. You're actually here for running a red light or not obeying the yield sign. So when you accept that ticket and go to municipal court, you're not admitting guilt. It's not evidence of guilt. It's not evidence of anything. It's just to let you know what you're being accused of. Does everyone understand?
Yes.
Is there anyone who's going to hold it against Mr. Dotson because he's here under indictment? All right. Now, everyone has a right to remain silent. What does that mean? That means that no one can call you if you're accused to testify. You have a right to testify or not testify. I've been a defense attorney. I've been a prosecutor. And I will tell you, sometimes as a defense attorney, I would tell my client, you don't need to testify. The state didn't prove their case. Or sometimes I would have clients who stuttered, who were always nervous because it's a serious case, right? And I would tell them, you know, it's probably best for you not to testify because the first time the jury's going to see you is you're testifying and you're already sweating and I'm the only person who's talking to you. So there are many reasons why somebody may not want to testify. The main thing and the rule is, and the law is that if someone decides not to testify, You can't hold it against them. You can't be Mrs. Kravitz on Bewitched and say, I wonder what they would have said. You're not allowed to do that at all. Does everyone understand? Is there anyone who's going to hold it against Mr. Dotson if he decides not to testify? If you are, raise your card. All right, that's number 2. All right, the next thing I want to talk to you is burden of proof. The state has to prove their case beyond a reasonable doubt. The defense does not have to do anything. When I was in law school, they would tell us, you can go to sleep. You all can play crossword puzzles. You can play video games. And the reason why you can do that is because you don't have to prove anything. The state has to prove their case. And that burden never shifts to the defense. So for example, if you were deliberating on a jury trial, right, on a criminal case, and you're in the back deliberating and you start talking to each other and you're saying, well, why didn't the defense bring this? Or should the defense have brought that? Then you know you have shifted the burden to the defense counsel's table. And that is never the case. Does everyone understand? And everyone is presumed innocent unless and until the state proves its case beyond a reasonable doubt. So right now, if on this case, you were asked if Mr. Dotson is guilty or not guilty, what should your vote be right now?
Not guilty.
All right. And that's because you have heard nothing about the case and Mr. Dotson is presumed to be innocent. Does everyone understand? Now, I know what people will say. Well, what's proof beyond a reasonable doubt? When I was in law school, there was a definition. You had to know that definition. If you didn't know that definition, you felt like a failure. I knew that definition. I knew it backwards and forward. My first trial as a defense attorney, I recited that definition. I put the commas where they should. I paused for dramatic effect, put the exclamation point where it should go. And then after I tried that case, guess what happened? There is no longer a definition for proof beyond a reasonable doubt. So the state cannot tell you what that definition is because there is not a definition for proof beyond a reasonable doubt. The defense cannot tell you the definition of proof beyond a reasonable doubt because there is no definition. So when I was a prosecutor and defense attorney, I said, well, how am I going to explain this to a jury? Because the definition doesn't exist. So I would explain it to the jury by telling them what it was not. Next door is the historical courthouse, the red brick courthouse with the green roof. That's where they try civil cases. Cases involving money, car accidents, their burden of proof is preponderance of the evidence. So it's more likely than not something happened. If you're ever deliberating on a criminal case, whether it be in misdemeanor court, felony court, or on the federal side, if you're in the back and you start saying, well, I think more likely than not this happened, then you know you are not at the correct burden of proof. Does everyone understand? The other burden of proof in the historical courthouse, that's their highest burden of proof, is what's called clear and convincing evidence. Clear and convincing evidence is the evidence that is needed to terminate your parental rights to your child. So that means they're saying, you're not a good parent. We think you will be a danger to your child. So therefore, you will no longer legally be this child's parents. That's their highest burden. Proof beyond a reasonable doubt is a higher burden than that. Does everyone understand?
Yes.
So proof beyond a reasonable doubt is the highest burden that we have. The next thing I want to talk to you about is fairness. The state and defense attorneys will usually ask people, can you be fair? Are you going to be biased? And sometimes they'll use the example of your car just got burglarized this morning. You're coming down for jury duty, or either your house was burglarized and you're coming down for jury duty. And it just happened, on a Monday. And here we are on a Wednesday, and you're called into court. And the next thing you know, the person is on trial for a burglary of a vehicle, or burglary of a home, burglary of a habitation. And then they say, well, you probably wouldn't be the right juror to sit on that case. That's not the correct question. What fairness means is that you will be able, if you are selected on a jury, to sit and listen to the evidence that's presented to you and base your decision on whether someone's guilty or not guilty, if you can come to a decision based upon what you hear. Does everyone understand? Because I will tell you, I think everybody has something maybe that has happened to in their past that maybe wasn't good. So when we talk about fairness in the court, it's not you putting that aside, what happened to you. It's basing whatever decision you have based upon the evidence that you hear. Does everyone understand? Is there anyone here who cannot do that in this case? All right, that's 2, 3, 26, 34, and 45. All right, the next thing I want to talk to you about is there are 2 phases to a trial. The first phase, people call it the innocent phase, but it's really not. The first phase is simply, did the state prove their case or did they not prove their case? It's not whether someone's innocent or not innocent. Does everyone understand? All right. So that is phase 1. If you find somebody not guilty, there's no phase 2, because phase 2 is what's called the punishment phase. In Texas, it's required that anyone who's accused of an offense and they go to jury trial, they must make a decision or an election on if they were found guilty, who would decide their punishment. Now, by making a selection, the person is not saying, oh yeah, I'm guilty. They're just following the law and the rules that say they have to make a decision. If they were found guilty, who would they want to do the punishment? Does everyone understand? So in this case, Mr. Dotson has decided that if he were found guilty, he wants the court to handle punishment. Does everyone understand? So if you're selected for this jury, you will not be involved in punishment if you were to find him guilty. Does everyone understand? Is there anyone who's going to hold it against him because if he were found guilty, he has decided to come to the court for punishment? Number 2. All right, the next thing I want to talk to you is about languages. I love languages. I think they're beautiful. I grew up in Louisiana. We had a choice. They were just bringing different languages into our school. Of course, I thought I would be retired by the time I was 24. Here I am, 23, still not retired. Okay. I'm testing your abilities. And so I decided to take French because I thought I was going to be living in Paris. I love the French language. I still try to go there every year. But my friend in school said, Stephanie, you should take Spanish with me. And I looked her in the eyes and I told her, when am I ever going to need Spanish? I'm going to be either in Louisiana or either I'm going to be in Paris. And so Tanya took Spanish and she's still in Louisiana with her Spanish. And I took French and here I am in Texas. So people in my law school and in undergrad and grad school, there were so many people from different countries, and you will find people from different countries. One of my friends speaks 8 languages fluently. And so I had people trying to teach me some Navajo, Arabic, Spanish. So what I've taken away from that is I can say hurry up in every language. But I'm working on my Spanish. So is there anyone here? English is not your first language. Please raise your card. All right, number 13. And when I call out your number, put your card down. 13, 31, 41, 44, 45, 46, 57, 58, and 61. All right, juror number 13. Yes. Have you been able to understand everything?
Yes.
All right, and what's your language? Your,
Spanish.
all right, juror number 31.
Yes, ma'am.
31. Somebody gonna nudge 31? You guys, I have my faith in you. All right, juror number 31, what's your language?
Spanish.
All right. Have you been able to understand everything?
Yes, ma'am.
All right, thank you. 41. Yes. What's your language?
Spanish.
All right, Stan. All right, have you been able to understand everything? All right, so you're gonna need to speak up. Have you been able to understand everything?
Yeah.
All right, thank you. Number 44. Yes. What's your language? Have you been able to understand everything?
Yes.
Thank you. 40, I think this is 45 or 43. 45. What's your language?
Spanish,
Have you been able to understand everything?
most of it,
All right, what does most of it mean?
I would say 80%, certain words, I can't, big words, I guess.
I'm sorry, what did you say?
Like bigger words, I cannot seem to comprehend them.
All right, so how much have you think you've understood?
Like 80% of it, I would say.
All right, thank you. 46. Yes, what's your language? Have you been able to understand everything? All right, thank you. 57. Yes,
Spanish, I've been able to understand.
thank you. 58.
Spanish.
And have you been able to understand everything?
Yes, ma'am.
Thank you. 61. Yes.
Spanish?
And have you been able to understand everything? All right, thank you. This is the first time we've only had Spanish speakers. Usually we have the Philippines and everywhere else. All right, the next thing I want to talk to you is about time constraints. It's expected by both parties that this trial will perhaps end by Friday. Is there anyone who has any time constraints or travel arrangements? You have tickets, you can't transfer them to me, raise your card. And when I call out your number, please lower your card. Number 1, 12, 16, 22, 23, 25, 31, 34. 32, you're coming in late. 32, 34, 47, 57, 58, and 64. All right, number 1, what's your time constraint or travel arrangement?
My time constraint actually is that I only have coverage for work for today. And we have people off for the next couple of days that I have to cover.
All right, thank you. Number 12,
Surgery on Monday.
back surgery on Monday.
Prep is Monday, surgery is Tuesday.
All right, thank you.
Yes, ma'am.
Number 16,
I have a disabled daughter, so I have to help my wife with her in the mornings, so I might not make it on time.
all right, thank you. Number 22,
I have a doctor's appointment on Friday that I can't miss.
all right, what time is it?
I think it's at 9:30.
All right, hey, you better be sure about that time. Number 23,
Mine is travel, but it's next week, Thursday, just in case it goes longer.
all right, where are you headed? What are you doing in California?
That stuff.
Thank you. All right. Number 25,
I work in a cath lab and I'm currently on call for after hours for STEMIs. So I do that for 2 weeks at a time. Yesterday it started.
all right, thank you. 31,
I got therapy for my niece
all right, and when is that?
Thursday at 10 o'clock.
All right, thank you. Number 32,
I have an eye appointment and a doctor's appointment tomorrow, and then I have an MRI appointment on Monday.
all right, thank you. Number 34,
Short staff at work and travels on Saturdays. Be gone next week.
all right, thank you. 47,
I'll be traveling all next week.
all right, where are you headed? What are you doing in DC?
Family.
Okay, all right, thank you. 57,
have traveling arrangements to go to Mexico, and I'm gonna be gone Friday till the 22nd.
All right, thank you. 58,
Your Honor, this person and
all right, all right, we'll take that up. All right, thank you. 64,
I'm supposed to be finishing my last 3 days of training for a new position this week.
did you let them know downstairs?
They said financial situations and that stuff would come later.
All right, thank you. All right, now I'm going to tell you all 2 stories, both are true. One, I realize that jury duty is an inconvenience. And I say an inconvenience because 1, you have to pay for parking. And I'm sure you're asking yourself, why do we have to pay for parking? We're coming down here to help you out, right? The other thing is downtown is a nightmare as far as construction, one ways. Sometimes the GPS is telling you different things that is not correct. And then when you finally find the courthouse and you're there and you're not at the courthouse on Frio, you're on a one way and you're probably thinking, it's right on the corner. I could turn. There's no traffic. Should I do that or should I just go around? And you go around and you finally make it here. And then you're running because I've seen people run to jury duty because they don't want to be late because it says 8 a.m. And I would tell them, slow down. It's a hurry up and wait situation. So you're waiting down there and then you're waiting in the corridors outside. It's an inconvenience. For example, how many people here have been on a jury panel before? Raise your card. If you ever been on a jury panel. So that's 2, 4, 5 people, 6. So that means everybody else hasn't been on a jury panel. The government only asks 2 things of you. They ask you to pay your taxes and they ask you to show up for jury duty. There is no draft anymore. They don't even ask you to vote, although I think everybody should vote, but they don't even ask you to do that. They're just asking for these 2 things. But yet people still want to wave the flag as though they're doing all of their duties when 2 things the government asks for you to show that you're a good citizen is pay your taxes and show up for jury duty. And I say it's an inconvenience because let me tell you what I define as a sacrifice. My uncle used to live in a small, he's since passed. He lived in a small town called Grand Cane, Louisiana. Super intelligent. They would skip him in class because the teachers would say, well, Miss Lane, we've taught him all we can teach him. And they just moved him to the next class and move into the next class. And of course, his sisters and brother, when they came up behind them, they were a little bit upset because the teachers were like, we're expecting a lot of you all because we've seen your brother. So you all had better show us what he showed us. So he graduates from high school. And when he graduates from high school, the Vietnam War starts. And he tells my grandmother, I want to sign up because there's nothing for me here. There's no way I can prove my lot in life because of the times they were living in. And so the reason why he was coming to her and telling her that is because she had to sign for him to go. That's a sacrifice. And for the young people, let me tell you how much of a sacrifice it was. Number 1, nobody really knew where Vietnam was. Number 2, during that time period, you had 3 stations, ABC, NBC, and CBS. And you only had NBC if the weather was just right. If it was cloudy, it's not going to play that well. Even if it's too much sun, it's not going to play that well. It had to be perfect. And then for the young people, guess what? Television wasn't 24 hours. News wasn't 24 hours. What would happen when the station was going off the air? If it was high-tech days, they would play the national anthem. The TV would go silent and the flag would just wave on the screen. NBC didn't do the flag. They just had white noise. Television is off. It's done. There was no computer, so you couldn't send an email. It was strictly letters. The phone, the way you have phones now, you can just dial somebody. Back in the day, you would pick up your phone because there were not numbers on it, and the operator would answer and you would tell them what number you wanted. That's why they had the song Beechwood 45769, because that was the number. You want Beechwood 45769. So when my grandmother sent her firstborn, and I think people know how people feel about their firstborn, she sends him off, and the only thing she can do is write him letters. His name and Vietnam. That's it. And hopefully it gets to him. And, you know, it would be 6 months later. And then, of course, during that time period, you had people getting knocks on their door with people in military uniform saying, "We are sorry." So she wasn't getting letters back because there was so much downtime between when she would write a letter and she would receive a letter. And for those of you who are in the military, you know, when you get to your destination as a soldier, the first thing they do is they tell you, write a letter back home to let them know you got there. So, of course, we saved all their letters. My uncle has since passed. My grandmother has since passed. But I always tell that story to people because when you think about being here at jury duty and how, oh my gosh, it's 8 a.m., we're sitting here waiting, or we're in the hallway, those are just inconveniences that your country is asking of you because we need jurors in order to have a jury trial. They're not sacrifices. The other story I want to tell you is my friend who was in law school. She decided to do civil law. I always wanted to do criminal law. That was my passion. And she told me one day, she said, "Stephanie, I have jury duty. Let's meet for lunch." I'm like, "Oh, great. Let's meet for lunch." So we're meeting for lunch. And no offense to civil attorneys, but they're usually not in trial as much as criminal law attorneys are. So we're having lunch and I ask her, "How is jury selection going?" She tells me it's going fabulous. Now that I'm a judge, how can it be fabulous? You were not with me in my court. But I tell her, "Okay, what do you mean by that?" And she said, "It's like when we're in law school. I'm on the back row, I'm keeping my head down, and I'm not answering any questions." So I start laughing hilariously. And she said, "What's so funny?" I said, "We're going to get to have lunch all week because you're going to be on that jury." So that is a true story. And I tell you all that is because the state and the defense attorneys, they're trying to get to know you. And they have this small opportunity to know you. The state is going to have 30 minutes to speak to you. After they speak to you, I'm going to give everybody their lunch break because while you were out in the hall, we were still working on other cases in court. All right? All right, state, are you ready to proceed?
Yes, Your Honor.
You may proceed.
Your Honor, would you please give me a 5-minute warning if I get to that point?
Yes.
Thank you. Lawyers love to hear themselves talk. And that's kind of antithetical to what we're trying to accomplish during the process, which is to learn more about you. So, to the greatest extent possible, I'm going to try and call on you individually to find out what you think. However, I am still a lawyer, which means I'm going to talk a lot. Now, Judge Boyd mentioned a love of languages. And she mentioned a particular word, bias. Does anyone know where we get that word? No? Bias comes to us from the French, specifically a game that they used to play in medieval France. It was a bit like bowling, except the ball was oblong instead of a perfect sphere. Because the ball was oblong, it favored one side as it rolled. Eventually, the Normans conquered England. They brought their legal system and their silly little game with them. As French transitioned to English, we dropped an unnecessary I, and that is where we got the term bias. It does not mean in and of itself something negative. It simply means favoring one side. And that is one of the primary things that we're trying to learn about all of you. What sides do you favor? It's not our job to make moral judgments about your beliefs. Right or wrong, good or bad, not interested. Except to the extent that you can't put them aside. Because in that case, You can't follow the law. You can't be impartial, and that means you should not serve on a jury. So, does anyone know what PG1 means? Okay. Juror number 8, would you please explain?
Penalty group 1 is classification for drugs.
And do you happen to know what those drugs in that classification are?
Could be methamphetamines, cocaine.
I'm sorry, I didn't hear that.
Sorry, methamphetamines and cocaine.
Juror number 8 is pretty well on the nose. Methamphetamine, cocaine, heroin, things of that nature. Now, does anyone among you believe that drugs should be legalized? If you believe that they should be fully legalized, please raise your placard. Right, if you believe that they should be decriminalized, please raise your placard. And keep it up until I call out your number. 1, 3, 24, 25, 30, 32. I apologize, I missed you 14, 34, 35, 37, 39, 40, 41, 42, 43, 44, 45, 47, 48, 52, 54, 55, 56. Am I going too fast for you? 60, 59, 62 through 64, 68 through 70, 72, and 75. Now, juror number 72, please rise. What's the basis for your opinion that drugs should be decriminalized but not legalized?
I was thinking of Colorado and how they decriminalized marijuana. It's something that I know there are medicinal benefits to marijuana. However, a PG1 I think should still be illegal.
Fair enough. You have a seat. Juror number 41. Would you please rise? Do you agree or disagree with juror number 72?
I don't agree with him.
And why is that?
Because what he said, marijuana and such a thing is good for health.
Okay, thank you. Please have a seat. Now, who believes PG1 drugs should remain illegal and that we should prosecute them? Please raise your placards. 2, 4, 5, 6 through 13, 15 through 21, 22 through 24, 26 through 29, 31, 33, 36, 38, 46, 49, 50, 51, 57, 58, 61, 65 through 67, 69 and 70, 71 and 72, 73 and 74. Now, juror number 8, why do you believe that PG1 controlled substances should remain illegal and we should prosecute them?
Given my background in law enforcement, part of my job with preparing cases for the court, and I've seen the effects of what happens to members of family who were affected by people who abuse the drugs. And with respect to the defendant, Mr. Dodson, and counsel, I will say that if I am selected, I would be looking at this case through the eyes of the state more than I would for the defendant.
I appreciate you being honest with us. Juror number 61. Would you please rise? Why did you give your answer? What's your thought process? Why you gave your answer?
Because as society, we're not ready to handle those drugs.
I'm sorry, could you speak up, please?
Yes, I don't think we are ready to manage that drugs without having a housing issue with people using them. I think that needs to be controlled.
All right, thank you very much. And juror number 38. Would you please rise?
I think all illegal drugs should be illegal.
All illegal drugs should be illegal?
I mean, yeah,
I think I get what you mean. Why do you feel that way though?
but just like juror number 8, am I correct in the number?
So because of the negative
Yeah, yeah,
harms that they
Yeah.
cause to their users, to society in general?
yes.
All right, I appreciate you. Thank you. Are drug crimes a problem in our community? And for our purposes, we'll say that our community is Bear County. If you agree with number 5, that there are very serious problems, would you please raise your placard? 2, 4 through 7. And when I call out your number, you can lower it. 8, 11, 12, 14, 15 through 18, 20, 18, 26, 28 through 33, but juror number 33, your placard's backwards.
Oh.
It's all right. 35, 36, 38, 40, 57, 58, 71, 73, and 74. Who believes that it is option 4, somewhat serious problem? 1, 9, 10, 13, 19, 21, 23, 24, 27, 37, 41, 44, 45, 47 through 52. You can all put your placards down. 54 through 56, 60, 61, 65 through 70, and 72. How many of you don't have an opinion? 3, 22, 25, 39, 43, 46, 53, 59, and 75. Thank you. Now, we typically think of criminal offenses in terms of their elements. Those are the things that the state needs to prove to a jury beyond a reasonable doubt for that jury to convict that person of that offense. The elements for possession of a controlled substance, of a possession with intent to deliver a controlled substance, PG1 4 to 200, is that on or about a specific date in Bear County, Texas, the defendant, and we must name a specific person with intent to deliver, did intentionally and knowingly possess a controlled substance, and we must specify what that controlled substance is in the amount of at least 4 grams to not more than 200 grams. The PG1 4 to 200 and the PG1 less than a gram are basically the same thing, except we don't need to prove that the person intended to deliver them to anyone. Now, those are the elements that we need to prove. Do we need to prove to whom those substances would be delivered? Juror 73. Oh, please stand. Thank you. Do we need to prove why the person intends to deliver those substances? Juror number 54. Please stand.
No.
Correct, thank you. Do we need to prove from whom the person received their controlled substances? Juror number 42.
No.
Okay, so these are the elements of the offenses that we need to prove. Other things that are outside of those, we don't need to prove. Now, considering that, if we don't prove any of those things to you, how many of you would hold that against the state? Please raise your placards. This is a lawyer problem. We ask questions that are more complex than they need to be. So these are the elements. Is there anyone among you who would require the state to prove anything outside of those elements? None of you. Oh, great for us. Now, intentionally and knowing, those are the mental states that we need to prove. Intent is that a person acts intentionally with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the results. Juror number 21. What does that mean to you?
You need to prove to me why they did it.
Okay. Juror number 60. Do you agree with juror number 21? Okay. What in your mind?
I'm sorry. No.
What in your mind does that definition mean?
That they intentionally had the substance.
I can't hear.
That they intentionally had the substance.
But what does intentionally mean to you?
That they knew they had it, that someone found that they had it.
Okay. Thank you. Juror number 29. What does it mean to you? And thank you for standing.
Yes, sir. If I have to, from what I'm reading up there, with intent, that means this person was caught with this substance outside their home, so I'd have to wonder what they're doing with it. If they're selling it, distributing it to our kids, anybody of my family members, which have been on substances before and are currently living on the street. I have a niece. So this hits right hard at home. Whether, I don't care what the amount is. I don't do it. I don't think anybody else should either.
Appreciate you. I'd like to take this opportunity to remind everyone, though, that when we're presenting our case, we only need to prove the elements beyond a reasonable doubt. And one of those things that we don't need to prove is to whom would these substances be distributed? Who would ultimately be their consumers? Now, if that is in your mind and it is something that you feel makes you partial one way or the other, we would appreciate it if you would say so now, because it might mean that you are not an appropriate jury for this particular set of offenses. So does anyone concur with juror number 29? 2, 15 and 16 and 17. I knew you were 20, 26, 36, 31, 37 through 40, 44 and 45. I apologize for missing you. 43, 51, 53, 54, 58, and 62. Thank you. Now, there are two mental states, intent and knowledge. Person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Juror number 66. What does that mean to you?
Person is aware of what they're doing and the actions that could cause.
Fair enough. Please have a seat. Juror number 46.
The same, that that person knows what they're doing and what their intention is, what it's meant to be.
Okay. Juror number 31.
Yes, I agree with both of them.
Is there, you can have a seat now. Is there anyone who disagrees? All right. Intent to deliver. Juror number 18. If I recall correctly from the questionnaire that you filled out, you are a grocery worker, correct? You helped to stock the shelves overnight? And you've done that for about 18 years? So I assume that you stock the shelves at HEB because HEB intends to deliver its produce to other people, correct? But how do you know that that's true?
You don't get the question, like,
Sure. How do you know that HEB intends to sell its produce to others rather than just keep it all for itself?
put out for sale.
They put it out for sale. They advertise it.
Yes.
They have lots of it, way more than any one person would reasonably consume. They have a large variety of it. And they have tools of the trade, correct? What are some of the tools of your trade?
Sales.
Checkout aisles,
Yes.
some of those cool dollies that let you move big pallets of stuff.
Yeah.
All right. So if we present evidence such as this, juror number 33, what would that communicate to you?
That this person intended on selling these drugs to other people, maybe not knowing how it would affect those people's families, or could get in a car accident, being under the influence, whatever the case.
Okay, thank you. Juror number 55. I don't think I've picked on you yet. Not yet. What sorts of things would you expect to see from the state to prove intent to deliver?
I wouldn't know what to say.
That's a fair answer. You're gonna have a seat. By the way, if you don't know an answer to a question that I ask, or if my question is confusing, you can say, I don't know, or I didn't understand. That is a perfectly acceptable answer. So what does it mean to possess something? Some of you are married. Who among you is married? I want to pick on someone I haven't picked on yet. Juror number 74. Yeah. You're married?
33 years.
How long does it feel?
I'm sorry, I can't hear.
It was last Sunday, 33 years.
This is last Sunday, 33 years. So does it feel like 33 years or does it feel like 36? That's, no, you should say that it feels like we got married last Sunday.
It's her birthday today.
Oh, I apologize for you being here. Does your wife carry a purse?
Yes.
Has she ever given that purse to you to hold for her?
Do I have to admit that before?
Have a seat, I'll ask someone else. Who else is married? I haven't picked on you yet.
Sure.
Does your husband have?
I'm sorry, what's your number?
Does your husband have a wallet?
Yes, it does.
Has he ever given you that wallet to hold?
Always.
Always. I'm curious, why is that?
That's what stress.
Because
And
he-
there are no secrets, and it's not a problem.
Is it because he trusts you more than himself?
Yeah.
Yes.
For the most part, yes.
Someday I have a marriage like yours. Now, when your husband gives you his wallet, does that mean that you own his wallet and its contents?
No,
Why not?
because it's his possession, and that's his personal possession. It belongs to him, I'm just holding it for him. I have not owned it.
Fair enough. So even though you don't own it, you can still possess it, correct?
Correct.
Okay. Is there anyone who disagrees with that sentiment? That if you possess something, that means you must, by definition, own it? No. Oh, juror number 22.
I disagree with that because you have to have the knowledge that you have it. I think you could have something without like owning it and knowing that you have it.
Okay, would you please elaborate on that? Do you mean that you need to know that it's a wallet or that you need to know its contents?
Yeah, it's contents. Like she doesn't necessarily know everything she owns by holding the wallet.
Okay, and juror number 21, you have your thing kind of up.
Yeah, because if you were to say, hey, you know, you're married and your spouse is like using your car, right? So you are possessing that car, regardless of if you're on their insurance or not. And your spouse leaves their firearm in the car. You are now possessing their vehicle with their contents. So actual care, custody, control, and management, like you've taken ownership of that vehicle, so you now possess everything in it.
Okay. That brings up an interesting point. I'd like to try something out. See this pen? Hold on to this pen.
I'm not gonna take it back.
Fair enough. Just roll with me on this. Hold on. Oh, thank you. Okay. Now, juror number 20 possesses the pen. Mind if I have it back? Now, if I set it down and say, juror number 20, take care of that for me. And juror number 20 does nothing. Has juror number 20 possessed the pen?
No.
Why? Juror number 37.
I don't think he possessed that pen because.
I'm sorry, I
Oh,
can't.
sorry, I don't think he possessed that pen. Like, you could tell them to hold on to it, you can do all that. But in order for him to possess it, he has to knowingly like take care of it, knowingly like put it within himself. If he leaves it on there, let's assume that's still on your table. That's still in your possession because that's still your table.
Okay. Is there anyone?
5 minutes.
Thank you, Your Honor. Is there anyone who disagrees with juror number 37's interpretation? All right. So what we've been talking about are the ideas of care, custody, control, and management. If you don't exercise those things over an object, you don't possess it.
Well, can I ask a question since you got 4 minutes
And
left?
as long as you're willing to stand.
Stand up, I'm juror number 43, potential. I'd like to ask you a question about this possession thing,
Go for it.
because I don't watch a lot of local news, but I do watch federal news. And lately, a lot of stuff concerning the ATF and firearms and all that stuff has been in the news. And one thing that you always hear about is possession of a firearm, possession of a, and the simple fact is legally, is it constructive possession or real possession? Because if it's in the trunk of my car and I don't know about it, I get pulled over, for example. The sheriff decides to search my vehicle, and unbeknownst to me, there is 50 pounds of methamphetamines back there that I didn't know anything about. And I say, it's not mine, it's not mine. That's not gonna win in court. Doesn't constructive knowingly possessing, I took possession of it, I know it's there,
I'm now doing whatever I want to with it. That's the difference, in my opinion, between saying, take this pen, I'll be right back. Or you stick a pen in my pocket, I don't even know the pen's there. If there's two passengers in one car, guy's driving, the passenger, unbeknownst to the driver, is carrying everything under the sun. Cop pulls him over, guy dumps his pockets out onto the floor. Who is truly in possession of everything that was dumped into the floor? The owner, the occupants, thin air, who actually is in possession of it under the law? Now, not speculation, lawyer.
By the way, lawyer is derived from English and attorney is derived.
Attorney, I'm sorry, attorney.
Well, we say attorney because we want to sound fancy.
Okay.
Is there anyone who agrees with juror number 43's interpretation? Raise your placards. 1 through 6, 9 and 10, 7, 13 and 14, 15 through 21, 25 through 29, 30 through 33, 35 and 36, 37 through 42, 44 through 47, 51, 53 through 56, 57, 60 through 62, 66 through 68, and 72.
Sorry.
You don't apologize. This is kind of the point. We want to learn more about your views. Burden of proof, the judge has already gone over that, and hopefully everybody understand it, that reasonable doubt is essentially what you believe it to be. Do you need to know every aspect of a situation in order to understand the situation beyond a reasonable doubt? Juror number 49, I don't think I picked on you yet.
Can you read that one more time?
Sure. So this puzzle, we use this a lot. There's a piece missing, but do you still know what the puzzle depicts?
No.
Fair enough, have a seat. Juror number 48. Do you know what the puzzle depicts?
No, sir, that animal could be doing anything.
I'm sorry, can't hear.
That animal could be doing anything.
So you know it's an animal.
I know it's an animal, but I don't know what it's actually about.
Do you know what kind of animal it is?
No.
I'm gonna have to stop using this example. How about in this situation? Juror number 7.
What's the question?
Do you have a reasonable doubt about what has happened in this kitchen?
A lot of doubts.
A lot of doubt?
Yeah, no idea what's going on.
How about juror number 14? I don't think I picked on you yet.
They're guilty.
So, after you hear all of the evidence, you should ask yourself, based on that evidence, 3 things. Do I have a doubt? Is that doubt reasonable? And is that doubt concerning one of the elements? Because again, what the state needs to prove are the elements. So if you have doubts about why a person did a thing or who it would have affected, this may be very interesting, but they don't go to the elements. And so they are not something that you should consider as you deliberate.
Council time.
Thank you.
All right, ladies and gentlemen, I am going to give you your lunch break because the staff, of course, needs a lunch break. The court reporter needs a break because she's been typing down everything that everyone has said. You are not excused from this panel, though. Does everyone understand? And I know you're probably asking, why would she tell us that? She's going to tell us what time to be back. This is based upon experiences we have had where we've had to locate someone walking along the Riverwalk, enjoying the rest of their day. So you all are not excused from the panel. You will be back here at 2. I want everyone to look to your left. Look to your right. That is the juror that you are responsible for. When you leave, you need to take your items with you. We are going to lock the courtroom. You're not allowed to come inside the courtroom. You're going to be stationed outside. I know the outside is hot. We can go off the record. There's a cafeteria downstairs. You have beat the rush hour traffic to that cafeteria. There are also places along Houston Street. There is the eatery that UTSA just opened up. I only mention that because they're not that expensive, but the food is good. It's across from where Portello's used to be. Deputy Laura will let you know where that's located. And they're pretty fast. All right, so make sure you're back here by 2 so we can start.
We approach before the 3.
Yes.
Do not take your number. Do not take it.
Take it?
No.
Or take it. Hang on, I think they're. Are we okay to go, or do they want to talk? Hold on, hold on. Wait up.
Ladies and gentlemen, everything that you're to know about this case is to come from inside this courtroom. So do not Google any names because you're trying to figure out what's going on. Does everyone understand?
Yes.
And I know people will tell me, well, Judge, I don't have time for that. I have other things to do. Just do not do it. Does everyone understand?
Yes.
All right, and make sure those badges that you have, the stickers, make sure that you keep them on because sometimes attorneys are walking around the courthouse and they're talking about different cases. It may not be about this case, but sometimes people want advice on different things, all right? All right, everyone, enjoy your lunch. Leave your number behind, please.
Don't take the numbers. This is county. You know how hard it is to get one of those numbers? It's not in the budget. Not in the budget. It's not till next year.